All right, good morning. I'm Parole Officer Wagerson. I'm a hearing examiner for the Board of Pardons and Paroles, and this is a preliminary hearing concerning Keith Williams, inmate number 406426. Today's Tuesday, September 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office, as well as Mr. Williams' location at New Haven, CC. Sir, can you please state your name and inmate number for the record?
Keith Williams, 406426.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning, Attorney Jones, if you could introduce yourself for the record.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Williams.
Thank you. And Parole Officer Sullivan, if you can introduce yourself for the record as well.
Parole Officer Sullivan for Special Management Unit out of the Waterbury office.
Thank you. And present this morning for training purposes, we also have Parole Officer Tricello. So, sir, this is a preliminary hearing which has three purposes under Connecticut law: to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant a revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back out into parole supervision. If I find probable cause and determine if the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that the preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you, and this hearing is also being recorded. The testimony in today's hearing is being taken under oath, so Mr. Williams and Parole Officer Sullivan, can you please raise your right hands? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So, sir, first I'm going to read you your rights. Then we'll review the parole violation charges that the state and your parole officer is bringing against you. And then I will review and identify exhibits filed for the record. The state will also have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have that same opportunity. After the conclusion of this hearing, I will inform you of my findings, which will be based on available evidence. Do you have any questions about the purpose or the procedure before we begin with the hearing?
I don't believe so.
Okay. So you do have important rights to this hearing, which I'm going to review with you now. You have the right to be represented by an attorney, and you do have one representing you here today. You have the right to receive written notice of the charges of the violation. Attorney Jones, was written notice received by your client?
Yes.
Thank you. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. And at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, sir?
I do.
Thank you. So at this time, I'm going to have your parole officer read the charges that are being brought against you along with the information underlying the charge. So in regards to charge number 1, condition release direction residence, the charging officer reported.
I will report to my assigned parole officer as directed and follow the parole officer's instructions. I will be assigned to one of several levels of community supervision and agree to participate in programs as determined by my parole officer. I will live in a residence approved by my parole officer and will seek, obtain, maintain employment throughout my parole term or perform community service. The Vermont release direction. You shall notify your supervising officer prior to any changes in your residence, must be approved by your supervising officer and or the parole board. On July 17th, 2024, a home visit was conducted at your parole approved residence. During this visit, it was brought to your parole officer's attention that you had been evicted from this residence at the end of March of 2024. Your parole officer made attempts to contact you and your significant other by phone, but both phone numbers are out of service. On July 31st of 2024, parole reached out to the state of Connecticut Sex Offender Registry to check your compliance status. You are currently non-compliant. Your whereabouts were unknown from 7/17/2024 until 8/14/24.
Thank you. He's also filed the following exhibits, which I've remarked as state's exhibits for identification purposes. And Exhibit A, the Connecticut conditions of interstate parole. Exhibit B, the state of Vermont parole agreement. Exhibit C, the interstate violation notice. Exhibit D, the interstate parole violation report, and Exhibit E, the email correspondence from State of Connecticut Sex Offender Registry. Exhibit F, the State of Connecticut remand to actual custody. Attorney Jones, did you receive the notice of the parole violation report, and all the other documents I just marked for identification purposes?
Yes.
Thank you. Do you need to continue this hearing at all to obtain any evidence?
No.
And Attorney Jones, to my knowledge, we don't have any witnesses today, correct?
Correct.
Thank you. P.O. Sullivan, at this time, you have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations at this time.
But me?
No, she's talking to
Oh,
your
no, parole officer, yeah.
Sorry.
Okay, could you just repeat that? It went in and out, so I wasn't
Yes,
sure
no, that's
exactly.
okay. So I said, at this time, you have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations.
I don't have any witnesses, but I was trying to get in contact with Mr. Williams for, a couple weeks. Every phone number I had, I was unable to get in touch with him. I contacted family members. Nobody called me back. I believe it was his aunt or cousin in New Milford. So his whereabouts were unknown. He never at any point contacted me to let me know, hey, I've been evicted. I have a new residence. This is my address. So that was concerning. He never contacted the sex offender registry with a new address. So he's non-compliant with them as well.
Okay. Attorney Jones, this is now your opportunity to respond and make any short statements, call any witnesses, and testify with respect to probable cause and severity of the allegations.
Thank you. Just in regards to the sole charge, I would just note that my client reports that his parole was transferred to Connecticut, I believe, for supervision on November 14th of 2014. Thus, he's been in Connecticut under supervision for almost 10 years. He's never been non-compliant with parole or suffered any violation prior to this remand to custody. He does report being evicted, but he reports notifying his parole officer. He was on a minimum contact schedule, indicated to me that he was reporting once a year in person. He reports sending verification to the registry as well. And I would just note that Exhibit E, which purports to be an email from somebody that works at the registry, however, does not identify the role of the person who's sending the email. It does not identify them as somebody who is working for the registry in any capacity. I would just put that on the record. I would also note that my client does not have any warrants outstanding for failure to register, and he certainly indicates that he notified his parole officer that he was evicted. And that's an unfortunate situation for somebody who was living in a community for almost 10 years with a great level of success, having no violations, maintaining employment, living with his family. So we would just note that he indicates that he provided that information to his parole officer, as well as provided a change of residence to the registry as well. There's no evidence submitted that my client did not provide his new address. And he does indicate to me that he has approximately 6 months remaining on the registry. And I think that's important to note because he isn't someone who's expected to register for a lifetime. He was only expected to register for, I believe it was a 10-year registration, and that registration period is almost over. And he's never had any violations of it whatsoever. So in terms of, a probable cause, I would note that, actually, I strike that. I would just note that in terms of seriousness, I would ask that you find that it not so serious to warrant further detention. This is my client's been living in this community for nearly 10 years. He was transferred from Vermont. He's never had a violation. There's, to my knowledge, at least not that I can see within this evidence, there's no indication that he was ever even issued a misconduct, no graduated interventions or sanctions. I mean, that's a significant period of time for somebody who's on this type of supervision to have no issues. And unfortunately, when someone's evicted, that's an unfortunate situation. He obviously fell on hard times to have that situation happen to him. He was living at the same residence in that community for, I believe it was over 9 years at that same residence. So we would ask that you find that it not so serious in the event that you are making a finding of probable cause, and allow him to be reinstated to supervision in the community. Thank you.
Thank you. Parole Officer Sullivan, do you have any additional closing statements or remarks that you'd like to make?
When I did remand Mr. Williams, I asked him, I was like, okay, if you guys tried to contact me, what was the number, the phone number that you tried to contact me with? And if you sent me a text message, you didn't get a response. And he was like, oh, I don't think so. So while he was in the car, he asked me to contact his wife to let her know what happened. And when I put the number in, I've never had any text message from that phone number. And I said to him, I was like, if I didn't respond, shouldn't you ask me, like, hey, did you get my message? I always respond. I did not get anything from him telling me that he moved.
Okay. Attorney Jones, do you have any closing statements you'd like to make?
The only thing I would just add is that it does appear that he was on a very limited contact schedule, and clearly that may have played somewhat of a role in how this could have been lost in communication. That's all.
Thank you. Okay, so at this time, I'm going to notify of my findings of probable cause. In regards to charge number 1, condition release direction residence, I do make a finding of probable cause based on evidence and testimony presented in support of the alleged violation of parole. That includes Exhibit A, the Connecticut parole conditions, Exhibit B, the Vermont parole agreement, Exhibit D, the interstate parole violation report, and Exhibit E, the email from the state of Connecticut sex offender registry unit. It is noted that this is an interstate case. Mr. Williams is on parole via the state of Vermont, and moving forward, the state of Vermont will oversee and proceed with any further revocation processes regarding the charges. The state of Vermont will determine whether your parole will be revoked and if any sanctions will be applied. Are there any questions or comments before I conclude this hearing?
I just wanted my comments on seriousness to be noted.
Yes. Okay. Mr. Williams, did you understand my last comment that I made in regards to Vermont taking over your case at this point?
Not really.
So you are establishing that it's serious enough?
For an interstate case, which we received somebody from another state, I do not establish seriousness. Okay. I just establish probable cause. It is up to the state of Vermont to move forward and determine if it is serious enough and if they decide to move forward with a revocation process for him. Mr. Williams, do you understand that?
Yes.
Yeah.
Keith, we did have discussions about this, right?
And then,
yeah. So, my only additional advice to you would be that during any transportation to Vermont, that you don't speak to any law enforcement regarding your case, that it's inclusive of any parole officer that's transporting you, and that you wait till you get to Vermont and request counsel.
So pretty much everything I've done, built a new life and got remarried, and I've worked really hard, put myself through private counseling for 8-9 years to become a better person. And because a mishap happens, and which I do apologize, I should have tried harder to contact Ms. Sullivan.
Keith, I think all of that information is going to be very important for your counsel representing you in the matter in Vermont. So I don't think it's I don't think it's something that you did for nothing. I think it's something that you did to help yourself, and that's going to obviously help you in any proceedings that take place in Vermont.
So, yeah, no, I do have a full-time job too. Okay.
Yes, but like I said, Mr. Williams, at this time, Vermont is going to take over and they're going to decide to proceed in which way they choose. At this time, I am going to conclude the preliminary hearing. I'm going to go off the record. All right, so Mr. Williams,
All right.
you are all set, okay?
Okay, so what does this mean? This means I'm gonna go back to Vermont? Or
It
Vermont?
all depends on what parole in Vermont decides. It's up to them at this point. It's in their hands.
Okay,
Okay?
all right.
All right, thank you. You're all set.
Keith, if you have any other questions, please contact me, okay? We did talk about that, about whether or not Vermont will come to pick you up, okay?
Okay.
Okay.
All right, I'll have my wife reach out. Thank you.
Thank you.
Thank you, P.O. Sullivan.
Thank you.
Thank you. Bye.
Good morning. How are you?
I'm great. How are you? Good morning.
Not bad, not bad. All right, I'm going to connect to the facility in just a second. Is it PR?
Hearing examiner Wingertsman.
Yes.
So I have two hearings, one with you and one
Yep.
with hearing examiner Saunders at 10:15.
Okay.
But I see that you also have one at 10:15 with Attorney Jones.
I do. I can have
So-
him go first and have
That
you go
would be
second.
my
if that works.
request. Yes,
Yeah,
I think that
not
might
a
work
problem.
better. Thank you.
Not a problem. Perfect.
Hi, good morning. How are you?
Good. How are you doing, Miss Williams?
Good. I'm just waiting for him to get here.
Yeah, no worries. We can't start until 9:25 anyway, so no rush.
Okay. You said 9:45?
No, 9:25. Sorry.
25. Okay. Okay.
Yeah.
All right.
Couple minutes. So no worries.
Okay. Thank you.
Today, your last hearing day.
Yes, it is.
It's been nice working with you.
You as well. Thank you very much.
You're welcome. I wish you the best. And are you doing the old 1584 hearings now with the new
Yes.
statute?
Yeah. Yeah.
Good luck with that. I've done one of those
Thank
in the
you.
past.
Yeah. No, thank you. Appreciate it.
Yeah. At least I began one.
Hello. How is everybody doing out there tonight? I'll be stepping in and out, during these hearings. I'm gonna be doing a lot more of these hearings throughout, the coming weeks and whatnot. I'm just trying to figure out like the setup I'm gonna be using, and so definitely be on the lookout if you do like these hearings and whatnot. I'm gonna be doing them a lot more often. All right, I'm just I'm adjusting my my microphone, and somebody should be coming up shortly. Just for those of you that are not aware, this is not live as far as the board hearing. This happened earlier on in the morning. I'm just getting around to it right now to streaming it. And the reason I'm doing like this is because if I don't do it by tonight, the hearing will disappear and it'll be gone. So I gotta find a way in order for me to be able to archive these board of parole hearings, and I find that this will probably work best for me, and I could double back to it. So here we are.
They should be starting in about 5.
All right, looks like we got our next gentleman coming in, or should I say next incarcerated individual.
Good morning, Mr. Ramon. We're going to get started in just a moment, okay?
Okay.
All right.
So,
All right, good morning. I'm Parole Officer Wangerson. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Amir Ahmad, inmate number 284321. Today is Tuesday, September 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office, as well as Mr. Ahmad's location at Osborne CI. Sir, can you please state your full name and DOC inmate number for the record?
Amir Ahmad, inmate number 284321.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Attorney Felipe, if you don't mind introducing yourself for the record, please.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit. Hello, sir.
How you doing?
Also present, we have Parole Officer Trissello for training purposes. Sir, this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of the evidence. That is, the better or weightier evidence must establish that, more probably than not, the allegation is true. I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole. I will reinstate your parole, which means releasing you and placing you back out into parole supervision. If I find that you violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to the panel for final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is also being recorded. The testimony in today's hearing will be taken under oath. Mr. Ahmad, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
All right, thank you. So first I'm going to read your rights, then I'm going to review the parole violation charges that the state and your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all of the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or the procedure before we begin?
No, ma'am.
Thank you. So, sir, you have important rights to this hearing, which I'm going to review with you now. You have the right to be represented by an attorney. You do have one representing you here today. You have the right to receive written notice of the charges of violation. Attorney Fleming, was written notice received by your client?
Yes, it was.
Thank you. You have the right to review the evidence against you before this hearing, and you also have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all these rights, sir?
Yes.
Thank you. So I'm now going to read the charges that the state and your parole officers bring against you and the information underlying each charge. So in regards to charge number 1, condition release direction reporting, the charging officer reported that on May 9th, 2024, you were instructed to report to the Hartford District Office to meet with this PO for scheduled reporting. You failed to report to this PO on 5/9/24. As a result, you violated condition number 1, release direction. Part 2 of the charge, on 5/9/24, this PO left a business card with your sponsor at 24 Vernon Street, Hartford, instructing you to report to the Hartford District Office on 5/13/24 to meet with this PO. You failed to report to this PO on 5/13/24. As a result, you violated condition 1, release directions. On charge number 2, condition release direction residence, the charging officer reported that on 5/9/24, this PO conducted a home visit at your parole-approved residence located at 24 Vernon Street, Hartford. This PO was informed by your parole-approved sponsor that you were last seen at or around 4/27/24. You failed to stay at your parole-approved residence and left your residence without this PO's permission. As a result, you violated condition number 1, release direction. In regards to charge number 3, condition release direction absconder, the charging officer reported that on 5/9/24, this PO left a business card with your sponsor at 24 Vernon Street, Hartford, instructing you to report to the Hartford District Office on 5/13/24. As of 4/23/24, you stopped all communication with this PO and your whereabouts in the community are unknown as of 4/23/24. As a result, you violated condition number 1, release directions. In regards to charge number 4, condition obey all laws, obedience to the law. The charging officer reported on 4/20/24, you were issued a misdemeanor summons by Hartford Police Department for violation of Connecticut General Statute 53A-109, criminal trespass in the 3rd degree, with a scheduled court date of 5/3/24 at 9 a.m. at Hartford Community Court, located at 80 Washington Street, Hartford, Connecticut. On 4/29/24, you were issued a misdemeanor summons by Hartford Police Department for a violation of Connecticut General Statute 53A-109 for criminal trespass 3rd degree, with a scheduled court date of 5/10/24 at 9 a.m. at Hartford Community Court, located at 80 Washington Street, Hartford, Connecticut. You failed to appear in Hartford Community Court as scheduled on 5/3/24 under docket H14C-CR 24-1-0191-702-S and on 5/10/24 for docket H114C-CR 24-0191-853-S. Both cases were continued to 5/29/24, at which time you again failed to appear. On 5/29/24, a rearrest order was issued by the court for 2 counts of criminal trespass, as well as 2 counts for Connecticut General Statute 53-A-173, failure to appear. On 6/28/24, you were arrested by Hartford Police Department with the following new criminal charges: Connecticut General Statute 53A-109, criminal trespass, and Connecticut General Statute 53A-167A, an interference. The state also filed the following exhibits, which I'm going to mark as the state's exhibits for identification purposes. We have Exhibit A, the Connecticut conditions of parole. Exhibit B, the remand to actual custody order. Exhibit C, the notice of parole violation. Exhibit D, the parole violation report. Exhibit E, business card with reporting instructions. Exhibit F, the Hartford Police Department case incident report 24-009852. Exhibit G, the Connecticut Judicial Branch pending case detail. Exhibit H, the Hartford Police Department incident report 24-010646. Exhibit I, the Connecticut Judicial Branch pending case detail. Exhibit J, Hartford Police Department incident report case number 24-016314. And Exhibit K, the Judicial Branch pending case detail. The state also filed an addendum to the parole violation report, which is being admitted to evidence and reads as follows. On 5/24/24, the Board of Pardons and Parole issued a warrant for re-imprisonment based on Parole Officer McClay's report. Parole Officer McClay's parole violation report. On 5/31/24, the case was transferred to the Fugitive Investigations Unit and assigned to Parole Officer Howlett. On 6/28/24, HPD South Street Crimes Unit apprehended Ahmad Amir, inmate number 284321, on his absconder warrant. Ahmad was also charged with violation of Connecticut General Statute 53A-109, criminal trespass, and 53A-173, interfering with an officer, and served 2 active prawn warrants for criminal trespass arrest on 4/20/24 and 4/29/24, and failure to appear 2 counts in Hartford Community Court on 5/29/24. A remand to custody order was lodged with Hartford Police Department's booking unit as approved by Parole Supervisor Waldron. On 7/1/24, Ahmad appeared in Hartford Superior Court GA14 for arraignment under docket H14C-CR 24-019-1702-S and docket H14C-CR 24-019-1853-S, as well as H14C-CR 24-019-2378-S. Probable cause was established on all charges, and the bond was set at $500 for each case. Ahmad's ex-court date is scheduled for 7/22/24. On 7/2/24, Ahmad was served a notice of parole violation and parolee rights at Hartford Correctional Center. The signed notice of parole violation, parolee rights, remanded custody order, Hartford Police Department incident reports, and Connecticut Judicial Branch pending case details were uploaded to case notes on 7/3/24 and are listed in final attachments under parole violation evidence. In reference to parole violation report submitted by P.O. McClay, the following applies. On 5/24/24, the Board of Pardons and Parole issued a warrant for re-imprisonment based on Parole Officer McClay's parole violation report. On 6/28/24, HPD South Street Crimes Unit apprehended Ahmad Amir, inmate number 284321, on his absconder warrant. Ahmad was also charged with violation of Connecticut General Statute 53A-109, criminal trespass, 2 counts, and 53A-173, interfering with an officer, and served 2 active prawn warrants for criminal trespass arrests on 4/20/24 and 4/29/24, and failure to appear, 2 counts in Hartford Community Court on 5/29/24. A remand to custody order was lodged with Hartford Police Department's booking unit as approved by Parole Supervisor Waldron. On 7/22/24, Ahmad appeared in Hartford Community Court under dockets H14C, CR 24-019-1702S, H14C, CR 019-1853S, and H14C, CR 24-019-2378S. Disposition is as follows. Connecticut General Statute 53A-109, criminal trespass, 3rd, guilty, unconditional discharge. 53A-173, failure to appear, 2nd, nollie. 53A-109, criminal trespass, 3rd, nollie. 53A-173, failure to appear, 2nd, nollie. Docket number H14C, CR 24-019-2378S. Connecticut General Statute 53A-109, criminal trespass, 3rd, nollie. Connecticut General Statute 53A-109, criminal trespass, 3rd, nollie. Connecticut General Statute 53A-167A, interfering with an officer, resisting, nollie. Attorney Fleming-Getty, did your client receive the notice of parole violation, the parole violation report, and all the other documents I just marked for identification purposes?
Yes, he has.
Thank you. And the defense also submitted the following exhibit. I'm going to remark as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Attorney Fleming-Getty, to my knowledge, we have no witnesses today, correct?
Correct.
Thank you. Attorney Fleming-Getty, this is now your opportunity to call any witnesses, present evidence, and speak to any of the evidence that has been submitted.
Yes, as to charge 1 regarding the preponderance standard, if you look to charge 3, they're saying that he absconded and his whereabouts were unknown from 4/23/24. If that's true, if his whereabouts were unknown, how would his PO be able to give him notice to report on 5/9 and 5/13? Also, the PO admitted that on 5/13, that he or she left a card with his sponsor. That's not notice. That's enough to carry. That's not enough evidence or weight to carry that he was actually notified of the 5/13 address because the card was given to his sponsor. He would have absolutely no way of knowing that he had a duty to report on 5/9 or 5/13. As to charge 2 regarding the preponderance standard, there's no information that he had any intention or did change his permanent address, or he had no intention of returning there. The only information we have is that on a 5/9 visit, someone purporting to be his sponsor said, I last saw him on April 27th. That's not enough, in my estimation, to prove the elements of residence. As to charge 3, I have no comment regarding absconder. And as to charge 4, all of the charges were nollie to save 1 criminal trespass and the 3rd unconditional discharge. These cases were prosecuted in the community court, so the most he could have gotten anyway, even though they are misdemeanors, Class C misdemeanors, is community service. Thank you for your time regarding the preponderance standard.
Thank you. Just give me a moment before I announce my findings. I just want to look into a couple of things. Okay, I'm now going to announce my findings. So in regards to charge number 1, I make a partial finding that you violated condition of release direction reporting. This is based on evidence provided in support of the charge, which includes Exhibit A, the parole conditions, which do indicate that the parole officer instructed him to report on 4/23/24 for that 5/9 date that he failed to report to, as well as Exhibit D, the parole violation, or the parole conditions, or Exhibit A, I apologize, and Exhibit D is the parole violation report, which I said prior, indicates that the parole officer met with the parolee on 4/23/24 and instructed him to report on the 5/9 date. I made a no finding with regards to part 2 of the charge. As the state failed to submit sufficient evidence to support this charge, as a result of insufficient evidence, the elements were not met. There was no evidence submitted to indicate that the parolee was directly made aware of the instruction to report, as it reads as though the sponsor was given that information to report, not the parolee. In regards to charge number 2, I find that you violated condition of release direction residence. This is based on evidence provided in support of the charge, which again includes Exhibit A, the parole conditions, and Exhibit D, the parole violation report. In regards to charge number 3, I find that you violated release direction absconder based on evidence provided in support of the charge, which again includes Exhibit A and Exhibit D. Exhibit A, the parole conditions, and Exhibit D, the parole violation report. In regards to charge number 4, I find that you violated conditional bail laws obedience to law. This is based on your conviction for criminal trespass 3rd degree on 7/22/24. Although the additional charges were not laid on this date, this does not negate that the behaviors occurred based on the evidence that was reviewed. Additional evidence provided in support of this charge includes Exhibit A, the parole conditions, Exhibit D, the parole violation report, Exhibit F, the Hartford Police Report dated 4/20/24, Exhibit G, the Judicial Branch pending case detail for the docket ending in 7/02, Exhibit H, the Hartford Police Report dated 4/29/24, Exhibit I, the Judicial pending case detail with the docket ending in 8/5/3, and Exhibit J, the Hartford Police Report dated 6/28/24. So this concludes the fact-finding portion of this hearing. Before I make my recommendation, Attorney Filimagetti, you have an opportunity to speak to your client's background and history at this time.
Thank you. Regarding the charge, these are very, very, very minor charges. Received an unconditional discharge for criminal trespass in the 3rd degree, which is a Class C misdemeanor. He would have been, the most he could have gotten in community court was community service. And there are 2 degrees of criminal trespass that are actually more serious than this, even though a criminal trespass in the 1st degree is not serious either. He was only gone for approximately 2 months after he absconded. The PO was recommending a total revoke. He's been incarcerated since June 28th. I think that's quite serious, quite draconian. He received no graduated interventions or sanctions. He's 42, a lifelong resident, single. He has 2 children. One of his sons is studying engineering at the University of Hartford. That's his oldest son. He gets his primary support from his mother, father, and his significant other, Liz Menard. He has his high school diploma. He completed some college courses, 2 years worth in applied sciences through Assunta Community College. In 2019, he established his own landscaping business, A&A Rescue Landscaping and Property Management in Hartford. He was rebuilding his customer roster, and he'd also worked as a dishwasher and a barback for a month and a half. He can return to his business, his landscaping and property maintenance business. He wishes to be sponsored by his parents in Hartford. We have the information there in our report. While incarcerated, he attended AA and NA meetings. He's been drug-free for over 3 years, and he's treated in the past at CRT, Wheeler Clinic, Rushford Treatment Center, Stonington, the Salvation Army. Like I said, he suffers from a creatine issue, and he needs his levels to be checked regularly. I believe he has a significant amount of ties to the community, his job. He's got a great job prospect. Unfortunately, the unfortunately, when he did leave, he was only gone for a short period of time and received criminal trespass conviction, which, as I said, is very minor. I don't see there's any reason whatsoever to totally revoke his parole. I'd ask that he be given a short period for a sanction. As I stated, he's been in since June, so that he can establish a track record with parole before the end of his sentence in April. Thank you.
Thank you. Thank you. I'm not going to announce my recommendations. So in regards to my recommendations, I am recommending that your parole be revoked and you serve an approximate 9-month period of confinement as a sanction, which is a revoke and no new re-parole date. Your special parole term is set to end on April 1st of 2025. It is noted that you have 3 prior special parole violations, all of which involved absconding from parole. And you were only most recently in the community under supervision for 8 days prior to absconding for a 4th time. And while on absconder status, you were arrested for additional criminal offenses. In the event the parole board decides to lessen my recommended sanction, I recommend the following conditions. No alcoholic beverage consumption, no contact with co-defendants Telly Smith, Miguel Rivera, and Angel Baez, no contact with family of victim WW. And although it is indicated by the defense that Mr. Ahmad would like to parole to his sponsor, this is the same sponsor that he previously absconded from, and a halfway house placement may be more appropriate. So I am going to be adding a halfway house placement recommendation as well. So my findings and recommendations will be forwarded to the board. You will receive official written decision from the board. The next board review is going to be on September 26th of 2024. So the board may decide to lessen the recommended sanction, or they may decide to let my recommended sanction stand in this case. Do you have any questions before we conclude this hearing?
Okay.
No questions for your attorney either?
No.
Just
Okay.
give me a call after the 26th of September, sir, and I'll let you know what the board decided, okay?
All right.
Have a good day, sir.
You too.
All right. Thank you very much. This concludes the revocation hearing, and I'm now going off the record. Thank you.
I'll see you back after you speak with Attorney Jones at 10:15.
Yes, absolutely.
Okay.
Thank you.
Thank you.
Hi, how are you? Do you have Mr. Hornberger there?
So, can you hear me?
Yes, I can.
He refused to come.
Okay. All right, I'm gonna go connect with my supervisor really quick and
Yeah.
just give me one moment, okay?
Yeah, do what you got.
Thank you. Hi, officer.
Yeah,
So, can I just have your name quickly for my records?
yeah. AG
Yeah,
UI
yeah.
RRE.
RRE, perfect. And just to clarify, so this is Richard Hornberger. He was aware that he was scheduled for parole revocation hearing today?
Yeah, I notified his bubble, the unit officer, and then they called me back and they said he's refusing to come. And I said, "Are you sure?" She's like, "Yeah, he refused to come."
Okay, all right, thank you. I just wanted to note that for the record,
Yeah.
Richard Hornberger, inmate number 263930, was scheduled to have a revocation hearing today on September 17th, 2024. And per CO Aguirre, am I saying that correctly?
Yeah.
Okay.
Mr.
Mr. Hornberger is refusing to participate in today's hearing. But thank you, sir. I appreciate it, all right?
Yeah.
You take care.
Pleasure.
Bye.
Yeah, look.
Good morning.
Oh, CO, I'm going to be disconnecting from you in a minute, okay? Oh, here we go. Mr. Filimagetti.
Yes. So I don't know if, oh,
Yeah, I was made aware that Carl Robinson may not be available today.
They're on lockdown.
They're on lockdown.
okay. So,
Yeah.
yeah,
So
they have not,
we're going to have to continue the hearings.
All the Carl Robinson ones?
For Carl Robinson, yeah, I have, you have Mr. Jimenez, and then I have one other individual that Attorney Jones is representing today.
All right, and she's at Carl Robinson or trying to be at Carl Robinson right now for her first one with Counselor Sanders, hearing examiner Sanders.
Yeah,
She's in Paso announced that she's canceled.
Yeah.
Continuing those hearings to the 17th due to facility.
Okay.
Yeah.
So Carl Robinson is canceled for today.
Yes.
Yeah.
Continue to.
Thank you.
Next
Yep.
facility.
Okay.
Available.
So we'll just keep on going with the normal times on the schedule.
Yes.
Thank you. Sorry.
No, that's okay. Thank you.
No worries. Hi, Ruth.
Hi, good morning.
Morning.
Attorney Jones,
Yes.
were you made aware of the facility lockdown at Carl Robinson?
Yes.
Yes. So we're
Oh, so
actually
that
gonna,
affects Mr. White as well.
it does, yes.
Got it. Okay.
So I'm gonna come back on the record at 10:15 for their scheduled times, and I'm just gonna have to continue their cases on the record, to the
Okay.
next available hearing date.
Would that be 9:23 for you or no?
Yes, yes.
Okay.
Yeah, that is the next date.
Okay. All right.
Yeah.
I'll pop back on. Thank you.
Thank you. Attorney Jones? Attorney Jones?
Yes, sorry.
Hey, no, that's okay. I'm just gonna go on the record really quick with regards to Mr. White's case and do the continuance on the record, okay?
Okay, and what about, did you have one with Rob, I thought? Or no?
I did make him aware. I don't know if he's gonna be logging back in.
He
but I
said
did
he's
make-
not going, yeah, he's not going to be, so,
Okay, not a problem.
yeah.
Let's just get on the record. All right, good morning. I'm hearing examiner Wangersman, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Dwayne White, inmate number 227845. Today's Tuesday, September 17th, 2024. This hearing is conducted via video at the Board of Pardons and Paroles. Present, we have Parole Officer Trusillo for training purposes and Attorney Jones, who is representing Mr. White. For the record, at this time, we've been notified by Carl Robinson, CI, that their facility is on lockdown until further notice. Therefore, Mr. White is unable to be present today for his revocation hearing. I am going to continue the hearing for the next available date to take place on Monday. I believe it's Monday.
It's Monday, yes.
Monday, September 23rd. So his case will be continued till Monday, September 23rd. Do you have any questions, Attorney Jones?
I do not, thank you.
All right, thank you. I'm now going off the record. Thank you very much.
Thank you.
Morning, I'm Parole Officer Wangersman. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Michael Jimenez, inmate number 318215. Today's Tuesday, September 17th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office. Present this morning with me as well is Parole Officer Trusillo for training purposes. For the record, Mr. Jimenez is currently incarcerated at Carl Robinson CI. We have been notified this morning that Carl Robinson CI is under lockdown until further notice. Therefore, Mr. Jimenez is unable to be present today to participate in the scheduled preliminary hearing. Therefore, I'm going to continue the hearing to the next available hearing date, which is Monday, September 23rd, 2024. Again, Mr. Jimenez's case is being continued to September 23rd, 2024. This concludes the hearing. I'm now going off the record.
And let her know that it's over.
Officer Pearson? Hello?
Yes, how are you doing? I'm here.
I'm good. How are you? I sent you an email a couple minutes ago.
Thank you.
I actually just went on the record. We were notified that Carl Robinson is under lockdown until further notice. So I actually just continued Mr. Jimenez's case. His prelim is now going to take place on Monday, September 23rd. Okay.
Monday, September 23rd.
Yeah, because he's like I said, Carl Robinson's on lockdown, and they're not able to have any inmates come down for any hearing. So he'll be heard on the 23rd. Okay.
Okay. Do you have the time for that?
I do not know, but when we send the docket out, we'll make sure we include you on the docket, so you'll have the time frame.
All right, thank you very much.
Yeah, no problem. You have a good day, okay?
You too. Bye-bye.
All right, take care.
Go.
Oh, hi, thank you. Is this Mr. Gonzalez?
Yes.
Okay, we'll be right with you. I just called the facility actually, so I'm just waiting for them to come back on the phone. I don't want to hang up, okay?
Okay.
Thanks.
Yep.
Okay. I'm Parole Officer Tricello, and I'm hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning Santos Gonzalez, inmate number 412603. Today is Tuesday, September 17, 2024. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cybulski Correctional Institution. Please state your name and inmate number for the record.
Santos Gonzalez, inmate number 412603.
Also present to observe is Parole Officer Wingertzman. This is a public hearing and public access to this hearing is available via video and live stream. Mr. Gonzalez, I'm going to swear you in as you're representing yourself pro se, and that way you can provide any testimony under oath if needed, okay?
Yep.
Please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury.
I swear.
So this is a preliminary hearing which has three purposes under Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that preliminary hearings, is an adversarial proceeding. Anything you say at this hearing can be used against you, and this hearing is being recorded. So we're going to go over the procedure for the hearing. First, I will read you your rights. Then I will review the parole violations charged that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. At the conclusion of the hearing, I will inform you of my findings, which will be based on the evidence available. That's pretty much it. Do you have any questions about the purpose or procedures before we begin?
No, you covered it pretty well.
Okay.
Yeah.
So you have some rights for this hearing, okay? You have important rights, and I'll review them with you now. You have the right to be represented by an attorney at this hearing. You may hire your own attorney, or if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney can represent you at this hearing?
Yes.
Do you intend to seek counsel for this hearing, or do you want to proceed without one?
We can proceed.
Okay. You have the rights to receive written notice of charges of violations. Did you receive the written notice?
Yes.
You have the right to review the evidence against you before this hearing. You also have the rights to submit evidence in support of your case. Have you submitted any evidence?
No.
This hearing, at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you have any witnesses for this case?
No.
All right. Do you understand all of these rights?
Yeah, I do.
Are you ready to go forward today?
Yes, I am. Yes, I am.
All right, we will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. Bear with me, there's a lot, okay?
Yeah,
All right. On charge number 1, conditions of GPS, the charging officer reported that on February 18, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device from 2 p.m. until 5:42 p.m. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electric outlet for at least 2 hours each day. On February 22nd, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device from 11:18 a.m. until 5:54 p.m. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On March 3rd, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in the full shutdown of the device from 10:36 p.m. until 12:38 a.m. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electric outlet for at least 2 hours each day. On the following dates and times, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device. On 3/15/2024 from 1:22 p.m. to 3/16/2024, 6:43 a.m. From 3/16/2024 at 7:38 a.m. to 10:11 a.m. On 3/16/2024 from 6:48 p.m. to 3/17/2024, 1:10 a.m. From 3/17/2024, 11:20 a.m. until 8:38 p.m. and 3/19/2024 from 5:43 p.m. to 7:04 p.m. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electric outlet for at least 2 hours each day. On May 18, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device from 8:20 a.m. until 7:37 a.m. on May 19, 2024. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electric outlet for at least 2 hours each day. On June 15, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device from 6 p.m. until 9:32 p.m. and 10:34 p.m. until 10:56 p.m. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electrical outlet for at least 2 hours each day. On the following dates and times, you failed to charge your GPS unit in accordance with your assigned GPS monitoring agreement, resulting in a full shutdown of the device. 6/27/24 from 9:17 p.m. to 9:22 p.m. and 6/30/2024 from 12:22 a.m. until 1:06 a.m. This is in violation of your signed GPS monitoring agreement. Specifically, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electrical outlet for at least 2 hours each day. On the following dates and times, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device. 7/4/2024, 8:02 p.m. to 8:28 p.m. 7/6/2024, 5:28 p.m. to 8:22 p.m. and 11:45 p.m. to 11:48 p.m. This is in violation of your signed GPS monitoring agreement. Specifically, I'm responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into the electrical outlet for at least 2 hours each day. On the following dates and times, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device. 7/15/2024 to 10:09 p.m. From 10:09 p.m. to 11:23 p.m. 7/16/2024 from 2:45 p.m. to 4:01 p.m. 7/18/24 from 9:59 p.m. to 10:32 p.m. and 7/21/24 from 5:06 a.m. to 6:15 a.m. This is in violation of your signed GPS monitoring agreement. Specifically, I'm responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. On charge number 2, condition of program participation, the charging officer reported that on 6/20/2024, this PO was informed that you were absent from relapse prevention program at community renewal teams on 3/15/2024, 4/26/2024, 5/17/2024, and 5/31/2024. On charge number 3, condition of search, the charging officer reported that on 4/13/2024, staff of the Watkins Halfway House instructed you to exit the bathroom in order to be pat searched, and to which you refused to comply with their instructions and therefore refused to be searched. On charge number 4, conditions of halfway house placement, the charging officer reported that on 2/26/2024, you signed out of the Watkinson Halfway House to attend a job fair in Vernon. A review of your GPS points placed you at various locations in the city of New Britain. Rather than returning to the halfway house after the job fair, this is in violation of your signed halfway house agreement. Specifically, I will go to the location indicated on an approved community pass. On 5/14/2024, you signed out of the Watkinson Halfway House at 11 a.m. for a job search purposes with a return time of 2:40 p.m. This PO received information that you were in locations that you did not have permission to be. On 5/15/2024, you admitted to this PO that you had contacted your ex-girlfriend and attempted to go to her residence, which you did not have authorization to do. This is in violation of your signed halfway house agreement. I will only go to locations indicated on an approved community pass. On 5/20/2024, you signed out of the Watkinson Halfway House at 1 p.m. for a job interview at Olive Garden in West Hartford. Upon review of your GPS points, upon exiting the halfway house, you appeared to be traveling at a rate of speed consistent with being in a motor vehicle. Upon completion of your interview, you appear to be traveling at a rate of speed consistent with being in a motor vehicle, at times speeds to in excess of 86 miles per hour. You made an unauthorized stop at an apartment building on Broad Street in Hartford. This is in violation of your signed halfway house agreement. I will only go to the locations indicated on an approved community pass, as well as I will not operate a motor vehicle, nor will I be a passenger in a vehicle without prior written approval from Parole. On 5/28/2024, Watkinson Halfway House staff was completing the house count, and upon entering the bathroom, you were in a stall with the door closed and a cloud of smoke permeating out of it. You admitted to smoking marijuana in the bathroom stall. This is in violation of your signed halfway house agreement. I will not consume or possess marijuana in the halfway house. On 7/17/2024, you signed out of the Watkinson Halfway House to attend a job fair on Park River Road in Hartford. Upon this PO's review of your GPS points, you were found to be in the area of Elizabeth Park in Hartford and traveling at a rate of speed consistent with being in a motor vehicle. You admitted to this PO that you left the job fair with a friend and were in a motor vehicle. This is in violation of your signed halfway house agreement. I will only go to the location indicated on the approved community pass, and I will not operate a motor vehicle, nor will I be a passenger in a vehicle without prior written approval from Parole. On 8/27/2024, during a routine compliance check at the Watkinson Halfway House, you were pat searched by Parole staff and then searched by DOC K9, yielding findings of a plastic bag with approximately 20 buds of leaf marijuana. This is in violation of your signed halfway house agreement. I will not consume or possess marijuana in the halfway house. The state has filed the following exhibits pre-marked for identification purposes, and I will read them as follows, okay? Exhibit A, notice of parole violation. Exhibit B, notice of parolee rights. Exhibit C, remand to actual custody order. Exhibit D, PCS signed conditions. Exhibit E, halfway house agreement. Exhibit F, GPS monitoring agreement. Exhibit G, attendee event history, charge history. Exhibit H, offender misconduct. Exhibit I, attendee event history, charge history. Exhibit J, offender misconduct. Exhibit K, Community Solution Inc. Disciplinary Action Report. Exhibit L, offender misconduct. Exhibit M, attendee event history / charge history. Exhibit N, offender misconduct. Exhibit O, attendee event history, charge history. Exhibit P, offender misconduct. Exhibit Q, Community Solutions Inc. Incident Report. Exhibit R, offender misconduct. Exhibit F, Community Solution Inc. Incident Report. Exhibit T, offender misconduct. Exhibit U, GPS monitoring agreement. Exhibit V, attendee event history and charge history. Exhibit W, offender misconduct. Exhibit X, residential discipline report. Exhibit Y, attendee GPS points. Exhibit C, offender misconduct. Exhibit AA, residential incident report. Exhibit BB, offender misconduct. Exhibit CC, attendee event history, charge history. Exhibit DD, offender misconduct. Exhibit EE, correspondence from community renewal team. Exhibit FF, residential discipline report. Exhibit GG, offender misconduct. HH, attendee event history, charge history. Exhibit II, offender misconduct. Exhibit JJ, attendee event history, charge history. Exhibit KK, offender misconduct. Exhibit LL, residential discipline report. Exhibit MM, attendee GPS points. Exhibit NN, offender misconduct. Exhibit OO, attendee event history, charge history. Exhibit PP, offender misconduct. Exhibit QQ, photo of marijuana contraband. Exhibit RR, Community Solutions Inc. remand report. And Exhibit SS, parole violation report. You mentioned that you have no evidence, correct?
Yeah.
Okay. Do you need time to continue? Do you want to continue this hearing in order to get any evidence, or are you still okay to move forward?
I mean, I'm okay with moving forward.
You're okay? Okay.
Yeah.
So today we have no witnesses. So now is your opportunity to respond to the parole violation charge against you. However, remember that you may remain silent if you choose to do so. At this time, you may testify regarding your case. Would you like to respond to the charges at this time?
Yeah, I would like to.
Okay.
But first things first, I would like to say, thank you for the opportunity of paroling in the first place. I had a game plan going out into the community on parole. I tried to sponsor straight from here, from incarceration to an address of a family member's. That didn't really work out. So I agreed to sponsor to the halfway house in order to get out into the community and just get my situation started. Upon getting there, I had the game plan. All right, I'm sitting here for at least a month or two, put in these other sponsors that I may have, get a job, and, be a productive member of society. Well, it didn't really work out quite that way. My 3 sponsors were denied. So then, that was kind of a shock or like a little stressful situation, I would say. But it's like, all right, whatever. The next option is the parole bed, like a reach house. Tried looking for employment various times. I did my best to make sure, I had a good resume, properly dressed, punctual. I just wasn't getting hired. I've had at least between 15 and 20 interviews my time at the halfway house. And I wasn't able to get employment for some reason. I don't even understand. Like, it's never been that hard ever to find a job in my life. I even applied to jobs I have job history for. So it's like I have experience in this just so I can increase my chances of getting hired. Anyway, the process wasn't going as planned. I was doing my programs, domestic violence. I completed that. I started relapse prevention just so I could get, passes out of the house because I felt, in a sense, trapped in a little bit because I wasn't getting no movement. I wasn't working, so I couldn't get family passes. So I just wanted some type of, out in the community time. During the time there, I acknowledged, I, at the end of the day, signed these conditions as far as like my passage where I would come back from wherever I needed to go. I had signed the papers stating that I'm supposed to charge my bracelet at least 2 hours a day, which is correct. And marijuana thing, I definitely acknowledge that, that those are rules and I signed for that. I was in the conflicting mindset where it was like, I had the game plan, it didn't work out. So now I'm just trying to limit the stressors, limit the opportunities, and like just trying to stay somewhat busy. And then also feeling like I had a right to see my friends and family because I did everything I needed to do to get out of jail early, you know what I mean? I did my programs in jail, I stayed out of trouble. It didn't work out the way I wanted to, where I could just sponsor a family so that way I don't have to feel the need to go see family, because I'll be sponsoring there. So it was a contradicting belief in like, I know I signed this and I know that I'm not supposed to do this, but then it's like, I also feel like I deserve to and I have a right to because I made parole. And the only thing that was really bothering me was the fact that I didn't have the privilege to sponsor to a family member's house. So in a sense, it was like, so am I on parole or am I in community release? Because it didn't feel like I was on parole in a sense, you know what I mean? I felt like I just halfway house, So I definitely took advantage of the times where I go on the path and instead of going to this program this day, I've been every other time. It was a birthday party, family birthday party. I'm like, I'm not gonna go. I'm gonna go see my family. You know what I mean? Like, I took that risk and I made that decision, understanding that you sign for things and there's consequences. But I take, full responsibility for my actions. I definitely was self-medicating with marijuana. That's my drug of choice. It's my only drug, really. And then, I took it in the house and I would smoke in the house because I spent most of my time in the house. So there was a lot of stresses in there too, people dealing with people, stuff's getting missing, you know what I mean? So it was just like, I was just trying not to overreact or crash out in a sense, like, lashing out, being disrespectful. I was self-medicating marijuana, especially since I know that it's legal and I'm allowed to. It's just the fact that I didn't get very many oftentimes to go out in the community and smoke it. So that's that. I try not to be disrespectful. I try not to get into no situations as far as with the law. My ex incident, that was kind of a little fishy line because I went to a temp agency and we're not together, but we're like on and off. She started a relationship with some other guy, but that's neither that. But we were still messing around, even though she was in a relationship. So she had called me and invited me over. And on the way there, it was like 45 minutes. I got there, I called her, no answer. I'm like, what the hell? Like, you just made me come over here. Like, So I go to the back, make sure her car is there. I'm like, okay, so she is here. All right. So let me go towards her window. Like, Zed, can you open? I'm here. Like, I'm trying to call you, not opening. Come to find out, her boyfriend ended up pulling up before I got there. So like, she had to play the, oh, I don't know. I didn't know he was coming. So like, that kind of backfired on me in a little sense, because now, like, I don't even understand how Parole got involved, but they made calls. Oh, he's over here. So like, I'm like, oh yeah, I'm not messing with this chick no more. Cause like, I almost just got in trouble for being, again, deviating. But that was that situation. As far as I tried my best not to get in trouble with the law. You know, I took risks and I made decisions understanding that there's consequences. I just had a contradicting belief where it's like, I feel like I have every right to do what I'm doing. I made parole. I did what I had to do to get out here. I'm supposed to be with family. Like, I'm sorry that my family are all on housing in Section 8 and can't afford to, you know what I mean? But I feel like I was being punished for it because I made parole, and on parole, you're allowed to smoke weed. As long as you're out in the community, say like if I were to sponsor your family, like the things that I got in trouble for at the halfway house wouldn't even be a thing. I would have not misconduct because I'm allowed to smoke, you know what I mean? It wouldn't be like, oh, he went out to this program but didn't come back because I'm out, you know what I mean? So most of these things I got in trouble for is because I'm at the halfway house, really, you know what I mean? And again, you know, I made those choices even though I know that there's consequences and I take full responsibility for that. But I don't think I believe that I wasn't, you know, I'll live with the consequences and stuff because I, you know what I mean? I did what I felt like I had every right to. I didn't hurt nobody. I didn't commit a crime. Yes, it sucks that I'm back in here, but it's temporary. I will be home. You know what I mean? I tried. I had a game plan. It didn't work out. I didn't know really what to do except to just stay out of trouble. Don't get into trouble with the law, which isn't hard for me really, but it's like there's also the rules of the halfway house that I was having kind of problems dealing with.
Okay. All right, Mr. Yeah. So I heard you and I've noted a lot of things that you just had a conflict of thoughts in your head when you were making your decisions.
Yeah.
Okay. Any other statements or information you'd like to add before I make my findings?
Yeah, I'll say again, thank you for the opportunity because it was an opportunity, and if things would have worked out how they worked out, it would have been a good step in the right direction, you know.
All right, then I'm gonna just take a few moments, go over what you just said to me, just make sure I have everything that the state provided, stuff like that, and then I'll give you my findings. Okay?
Yeah.
So I will notify you of my findings of probable cause. And I make the finding of probable cause on the following. For charge 1, I find that you violated the conditions of GPS. I've recognized the charge as 9 parts and have found that the following identified evidence supports the basis of all 9. Exhibit B, Exhibit D, Exhibit F, Exhibit U, and Exhibit SS. I will now add additional evidence to each part of the support to support the findings. So for part 1, I also found Exhibit G and H for support. For part 2, Exhibit I and J. For part 3, Exhibit M and N. For part 4, Exhibit O and P. For part 5, Exhibit V. For part 6, Exhibit C, C, and D, D. For part 7, Exhibit H, H, and I. For part 8, Exhibit J, J, and KK. And lastly, for part 9, Exhibit OO and PP. For charge 3, I find that you violated the condition of search based on Exhibit B, D, Q, and R. And for charge number 4, I find that you violated the conditions of the halfway house placement. I've recognized the charge as 6 parts, and I found the following identified evidence supports the basis of all 6. Exhibit B, Exhibit D, Exhibit E, and SS. And I will now add additional evidence for each part that support the findings. For part 1, exhibit K and L. For part 2, exhibit T. For part 3, exhibit X, Y, and Z. For part 4, exhibit AA and BB. For part 5, exhibit LL, MM, and N. And lastly, for part 6, exhibit SS. This evidence and testimony was all presented in support of the alleged violation of parole. So for on charge number 2, conditions of program participation, I do find a no finding of probable, I said that wrong. I find a no finding of probable cause based on the information reviewed during the preliminary hearing. So I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. The records office at the facility, as well as your parole officer, will be notified. At your revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. So the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. Do you have any questions?
Yeah. Okay, so I don't know if you guys have any knowledge about this, but as it stands right now, my end of sentence is October 18th.
Correct. Yes.
So if the revocation here is anytime after that, would I have to stay here?
Your parole term will be completed on October 18th.
So I will be released there then?
Yes, that's your end of sentence, correct?
Yeah.
Yes. Yep.
Okay.
Okay. Any other questions? If not, I
No.
will send you all of this in the mail. You'll get a copy of the summary and stuff we discussed today, okay?
Yep.
Okay, great. So this concludes the preliminary hearing, and I will now go off the record. All right, Mr. Gonzalez, you are all set, okay?
All right, thank you.
Have a good day.
You as well.
Bye.
All right.